Mr. Rusin, can you mute yourself, please?
It was me. Okay.
All right, I'm on the case of Velocity Investments LLC versus Carmela Anderson, 24169217. For Velocity Investments, please.
Yes, Your Honor. Christopher Royce, P49102.
Thank you, Counsel. Good morning to you. I'm looking now for Carmela Anderson. Say something, Ms. Anderson.
I'm here.
Okay, thank you, Ms. Anderson. Good morning to you. Counsel is also up to date on what's going on here. I do see an application for default. Go ahead, sir.
Yeah, we had filed that before we had received the answer. I spoke with Ms. Anderson, and she doesn't dispute the debt. We're just going to try to set up a payment plan. I've provided my contact information. I think that if the court issued a 60-day scheduling order, we would have it done well before then.
All right, Ms. Anderson, it seems to be the direction that this is going for you as well. That is, you're going to get this worked out and try to set up a payment plan. Is that what it is, ma'am?
Yes, sir.
All right, so I'm going to go ahead and set it on the normal track that I set these matters on. It's a 60-day discovery track and scheduling order. So that's going to bring you back in front of me. That's going to be it's going to be May the 13th.
May 13th?
Actually, May the 8th.
May 8th. Yes.
All right, so May 8th will be the next action date regarding this matter. If you got it worked out, then the appropriate paperwork should be sent in. Otherwise, you'll get a scheduling order from me to come back with a schedule to come back on May the 8th at 9:30 a.m. So I'm setting that on. You'll get some paperwork from me in the next couple of days. I wish both sides well. Good day to you.
Great. Thank you, Your Honor.
Thank you. That'll work.
You two have a great day.
You too. Bye-bye.
What I call case number 24-160040. This is City of Detroit. Sorry, this is Warrior Pharmacy versus City of Detroit. The matter is set for review and appears on a previous hearing in the case might very well be resolved. For Warrior Pharmacy, your appearance at this time.
Good morning, Judge Abdul Karim Saad, P8403 on behalf of Warriors Pharmacy.
All right, thank you, Mr. Saad. Good morning to you. For City of Detroit, your appearance, please.
Good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of defendant.
All right, thank you, Ms. Cobb. Good morning to you as well. I have all kind of notes about facilitation and settlement. Somebody tell me where we are at this point.
Well,
We're
Your
close.
Honor,
Oh, go ahead.
I was going to say we did have facilitation and we got closer, but as of this morning, we still had not resolved the case.
Very well. So I have this set up for a review hearing. Should I go ahead and set it for trial now, or you want me to give you a final pretrial conference date? Talk to me.
I'll leave that up to sister counsel.
I think a final pretrial date, Your Honor, and we're moving closer. I think that would help us.
All right. All right, I'll set the matter on for final pretrial conference. That date, just one moment. That date's going to be the 10th of April, 4/10, 4/10/25, 9:30 a.m. If the parties resolve it, we'll address that at that time. If not, I'll look towards setting the matter for trial. I know that there is some movement in trying to get it done, but we'll take a look at it on April 10th at 9:30.
Thank you, Judge.
Thank you, Judge.
The court now calls case number 23-165-235. This is WB Funding versus Sherelle Johnson. The matter is before the court on the filing of a motion for summary disposition of this matter. All right, your appearance for LVMB Funding, please. Do I have Sherelle Johnson on this Zoom? Ms. Johnson, if you're there, say something. All right, I'll come back to that matter at the end of the call to see where things are. The court is now calling for case number 05-134-867. This is Ford Motor Credit Company versus Henry Richardson. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect, excuse me, that a judgment was entered by default in this matter in 2006. That judgment was renewed in 2016. The judgment amount is $20,791.95. Your appearance for Ford Motor Credit, please. For Ford Motor Credit. Do I have Henry Richardson?
Yes, I do, Your Honor.
All right, thank you, Mr. Richardson. You have this outstanding judgment that you filed indicating that the writ was not properly issued or is invalid. What are you talking about there, sir?
Well, Your Honor, this is a unique case because what happened was I got incarcerated in 2006, and so the federal government had confiscated a lot of my stuff, which they confiscated that van also. And I'm not saying I don't owe them no money, but I think they got the van back and that they got some money for it that should be subtracted from it, and then I can make a payment plan to pay them.
Wow. Unfortunately, the issues that you're raising are not issues that this court can even take into consideration right now. You have a judgment that was entered in 2006 and renewed again in 2016. It sounds like you may want to challenge the underlying judgment. You could certainly file motions in that regard, but you can't attack the underlying judgment in the context of a garnishment. So I can't take those things into consideration at this time. Those objections would be invalid. Now, I know that they're taking 25% of your income. What does that come out to per week, sir?
Well, for 40 hours a week, I make like 700, maybe 700 a week. And already the problem.
Have they taken any money from you yet?
No, sir.
All right, so that garnishment is going to hit you about $250 or about $200 a week or $175. So you basically $800 or $900 a month is what the garnishment would look like, and you have a big judgment here. So you still have the right to kind of go after this and try to attack it under the underlying judgment by filing different motions. The judgment is old, so you have a hard time with that. What did you want to pay on a regular basis regarding this? That doesn't stop you from trying to attack the judgment, but what do you want to pay on a regular basis to try to deal with this?
Well, I was thinking, I was thinking like 300 a month, like $75 a week out my check. I mean, really, no one contacted me. I've been out like 4 years. I got a car, I got an apartment, I got all this stuff that I'm paying for. If they would have contacted me earlier, I could have made an agreement with them. Wouldn't have got a car, wouldn't have got some of these things. But I got a lot of stuff I got to pay for them. So, but I'm not saying I don't owe them. I want to pay them, but I can only pay them a certain amount.
All right, thank you. Thank you, Mr. Richardson. You told me all that one time before. I was trying to do something that could probably reduce the amount of the garnishment, but you're still talking about that. So I can't really do anything on that. So what I'm going to do is, what I'm going to do, look, I have a courtroom full of people to deal with. I'm trying to give you some direction to go forward. You still can raise all those arguments, but right now you have an immediate problem called a garnishment. All right, that's your immediate problem. There's nothing I can do to help you with that. So what you can do is you can file a motion for installment payments to ask the court about the amounts that you want to pay, because trying to talk to you about that, you want to go back talking about the other stuff. Ain't nothing I can do about that. So you filed your motion. I'll take it into consideration because I have to move on to other cases, sir. So the objections are invalid, but you do have the right to file a motion to get some installment payments, which will reduce the amount of your garnishment. I do wish you well, sir. Good day to you. All right, this is case number 18-140-719. This is Jefferson Capital Systems LLC versus, I believe it's Shalice Crawford. But the matter is before the court.
Shalice Crawford.
I think that you understand that when I'm calling the case, until I come to you, you don't interrupt me. How about if everybody do that? You can't do it that way, man. Just don't. Okay, there's no problem. I just don't want you to do it. You do that, everybody else can do that. All right. The matter is before the court on the filing of objections to a writ of garnishment. This relates to a judgment that was entered in this matter for $1,003.17. That judgment was entered back in August of 2018. Your appearance for Jefferson Capital, please. Jefferson Capital. All right, I don't see Jefferson Capital. Let me, Ms. Crawford, go ahead now and let me hear from you, ma'am, Ms. Crawford. You have something to say at this time, please.
Yes, I don't believe I owe them because actually I have a credit card still open with them, and they still trying to increase my account. And then they send me after I filed the case, and then they said, well, it's been over, I guess, so many years, and they was not able to sue me. I don't know what that meant.
Thank you, ma'am. So, ma'am, the issue that's before the court is the reality that there is a judgment against you. That judgment, as I mentioned, was entered in 2018. If you believe that that judgment should not have been entered, you would have to attack the judgment. The court rules do not allow me to take into consideration issues in the underlying case. It only allows me to consider at the garnishment hearing. It only allows me to consider issues like the funds being exempt, such as Social Security, or you have a bankruptcy proceeding, or you already have an installment order in place. The objections that you raise is that you don't believe the judgment should have been entered. I can't consider that now. You could file a motion to try to get the judgment set aside if that's what you wanted to do. But there is a judgment in place, and because
but I didn't even know about it.
Okay. All right. Thank you, ma'am. It looks like to me that I have a document saying that you were served with the complaint back in 2018 on Caldwell Street in Detroit. You did not respond to the complaint, and that's why the judgment was entered by default. That's the problem. The judgment was entered by default. You may have some basis to attack the judgment, but you can't do it in a garnishment hearing. A garnishment hearing is just what happened after the judgment is entered, not what happened before the judgment is entered. If you're attacking something that happened before the judgment was entered, then you have to file like a motion to try to get the judgment set aside. This is everything after the judgment. And this judgment has been in place since 2018. It's been in place for 7 years. And so you have to try to get it set aside if that's what you want to do. As far as the garnishment, the garnishment, there's a debt, you owe money. Therefore, they can garnish you. All right. So I don't see a valid objection to the garnishment in this regard now. And so I would have to find the objections invalid. Any funds withheld would have to be released to the plaintiff, given that there is no valid objection at this time. And again, it seems the issues you're raising is attacking the underlying judgment. You have to file a different type of motion to do that if that's what you want to do, ma'am. All right, I wish you well to you, ma'am.
Okay.
I am looking now to case number 24148443. This is Credit Acceptance Corporation versus Deshaun. The matter is before the court. Objections to a writ of garnishment. This relates to a judgment that was entered by default in October 24 for $14,520.91. The objection in this matter indicates that my address changed by the post service. I no longer live there, and no one was no order was received. All right, your appearance for credit acceptance, please.
Good morning, Your Honor. Attorney Ashley Nonis Hartman on behalf of plaintiff.
All right, Ms. Hartman, if you will, your P number for the record, please.
77029.
All right, thank you, counsel. Good morning to you. I'm looking for the Sean Living. If you
Right
also
here.
say. All
Right
thank
here,
you,
Your
Mr.
Honor.
All right, good morning to you, sir. I noted your objections here, and you said something about changing the address. Tell me what you're talking about, because it doesn't seem that there's anything attacking the garnishment here. Go ahead, sir.
What I was saying, because my bank account, when I entered this motion, my bank account got froze, and I went to my bank and they asked what was going on. Said it was a garnishment from credit acceptance, and the address where it went to, I thought by me going through the postal service and changing all my information so it could come to my new address, I haven't received anything. I looked over the court papers and saw that it got issued at a certain time, but I didn't receive anything to be forewarned of that, because as of right now, my bank account is frozen and it said there's 9 payments pending.
All right, so you wouldn't get any notice of a garnishment, sir. Once the judgment is entered, the garnishment comes as an element of surprise. The reason for that is because if a person finds out that you're getting ready to take their money, then they're gonna move the money before you find out. So that's if that's what the objection is, that's not really a valid objection. How much money is in the account at this time?
$2,800.
Right. Let me go to Ms. Notice. I'll come back to you, sir. Just Ms. Hartman. Ms. Hartman, you may at this time.
Judge, everything you said is accurate. So his objection is legally invalid. He does not receive notice of the garnishment from our office. He would receive notice of the garnishment from his bank. So if they have the wrong address, that's between him and his bank. So because his objection is invalid under the court rules, we are entitled to those funds.
Yeah, and unless you could tell me something else, Mr. Levin, they got you because of the outstanding judgment. And as long as that judgment is out there, sir, they're able to garnish bank accounts, income tax return, and able to garnish wages. It's that judgment that's in place. That's your challenge. Anything else you want to?
That's about it. I just want one question. How can I file another motion to get a payment plan set up?
You could certainly file a petition for an installment order. You could also speak with Ms. Nonis to try and set an amount. Let me ask you, knowing what the judgment is, how much are you proposing to pay voluntarily, sir?
$500 a month.
Ms. Nonis?
We can agree to that, Judge.
All right. So I will go ahead and sign an order allowing you to make a $500 a month payment. I suppose your first payment would be in the month of April. That makes sense to you?
Yes, that'll be fine.
All right. So the Fridays in April are the 4th, 11th, 18th, and 25th. Where do you want to put that payment in April?
What did you say, Your Honor? I missed that.
The Fridays in April are 4, 11, 18, and 25. Which Friday would you like that payment?
4.
So 4, 25. And so you know that your payment then would be due on the 4th of each month. On or before the first Friday of the month is kind of what you want to look at. To get the payment. So I'm going to sign an order to, you will need to make sure that you send that payment to the, I believe it is this the, I'm trying to make sure they have the right office, Mr. Beach's office, Madam Counsel. So, sir, you're going to that payment, you can contact that office and they'll tell you if there are ways to do it electronically, et cetera. And want to get all that set up in time to make sure that you make that April 4, 25 payment.
Okay, copy that.
All right.
And just to state for the record, Your Honor, sorry, I don't want to cut you off, but I want to let Mr. Living know that even with the payment plan, we are entitled to garnish your state taxes. So if you see a state tax garnishment, that will just reduce your balance if it hits for any funds.
Okay, copy that.
All right. I wish both sides well, and you'll get 2 orders from the Mr. Living as well as you, counsel, and that will memorialize the decisions that have been made on this matter today. The objections are found to be invalid. The funds are released to the plaintiff. An installment order is entered allowing for $500 per month commencing on 4/4/25. So.
Thanks, Judge. Have a good day. Thank you, Mr. Living.
Yeah, you're welcome. Have a good day. Bye-bye.
The court now calls case number 21-40374. This is Modern Financial Service Corporation versus Natika, last name Riley. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter in 2020 for the sum of $10,193.57. I did receive the objection to the writ of garnishment. All right, your appearance at this time for Modern Financial, please.
Yes, Your Honor. Good morning. Matthew Kuipers on behalf of the plaintiff.
All right, thank you, Mr. Kuipers, and good morning to you. I'm looking now for Ms. Riley. If you're on the Zoom, please say something at this time.
I'm here. Good morning.
All right, thank you. Thank you, Ms. Riley, and good morning to you. All right, so tell me, you say, number one, that the writ was not properly served, the amount deducted is not correct. Then you say you received the check from this company in the amount of $389. Tell me what you're talking about as far as your objection is concerned.
I received notice that I was getting garnished from this company. I believe it was 3/3 of 23. They gave me an amount and I was kind of going through a lot or whatever the case is, so I didn't answer it. I was making a little bit more money and I was like, I'm not even gonna lie to you. I'm just gonna eat it, right? The good thing about my job is they'll give you updates about how much, you are paying or whatever the case is. And so I'm thinking, I'm making my payments, everything is doing good or whatever the case is. But at the times where I would expect for the garnishment to be ended, it wasn't being ended. And I called my job and I was like, hey, I've gotten this much taken away from me and it says that the garnishment amount is this. And they're like, hey, we're sorry, but we can't do anything. This is the only thing we can do is just deduct until they say that the amount has been paid. So I told them, I said, okay, can you give me the paperwork that they have given you? And just to me, it seems like, I don't know if they're getting like the updates of how much I owed late. I know I'm not getting any updates about how much I'm paying, and I don't know if they're supposed to do that for me, but I do know that they were doing it for my job and the amounts appeared to be incorrect. I asked my job, can you give me a breakdown about how much I have paid them? And it looks like I've paid them over $2,000. And when I asked them and told them, they're like, oh, well, maybe it could be interest or maybe it could be this or whatever. And they gave me a letter, but not a court document. They gave me a letter that says that, hey, your amount has been paid, but since then I have still been garnished. And so that's why I have written this or whatever the case is, because I don't believe that the amount that they're taking from me is correct. And I don't believe that the calculations that they're either giving to my job or to the courts are correct, because the numbers appear to keep changing even while I'm paying them.
All right, thank you, ma'am. So, ma'am, this judgment started out a bit over $10,000. You can see that you haven't paid $10,000 since 2020, correct?
I did not pay that. As you know, COVID was a thing. No, I did not.
Thank you.
Your Honor, if I could.
Just one moment. A couple of things, Mr. Kuipers, is she's going to need an accounting from your office regarding this matter. And I want to know today, as best as you can tell me, what balance does your company show and how much has been paid?
Your Honor, this account has been paid in full. All the garnishments have been released. There's actually a refund check that was sent to the defendant for the $389.97. However, due to some issues with plaintiff's bank, there's some fraud issues going on. that check, the original check got voided and a new one has been since issued. And also, if the defendant would like, you can come pick it up in person. But at this point, all garnishments have been released, the account's paid in full, and there's a refund check that needs to go to the defendant.
Mr. Peppers, for some reason, your communication is very cloudy and I'm not able to hear what you're saying. So let me ask you a couple of questions, then I want to hear from you. Should there be any continuing garnishment? I did hear you say something about some money was being refunded. So update me again, if you will, in this regard.
No, Your Honor, all garnishments have been released. And a refund check was sent to the defendant. However, the original one got voided. There's a new one that's been issued, and that's for the $389. The account's been paid in full.
Oh. All right, so first of all, as it relates to the objection to the writ of garnishment, I will find that the objection is valid where the account has been paid in full. As it relates to the issue of a refund, there is one that is pending that Ms. Riley should receive. And also with that refund, I'm ordering that she receive an accounting from the plaintiff's office. And that accounting should describe what was received, what was applied to settle this, resolve this matter, and what the balance is. There's money owed back to Ms. Riley. That breakdown will show her exactly what that is. So as it relates to your objection to the writ of garnishment, that objection is found to be valid, and no garnishment may continue with regard to the workplace. And moreover, if it's a refund that is due to you, if when you receive, Ms. Riley, the refund and the accounting, if for some reason there is objection to the same, you have a right to file a motion to address any objection that you might have to the accounting. All right. I do wish both sides well. You'll get a copy of my order in the next few days. Good day to you.
Thank you, Judge. I do have one other matter too.
All right, just one moment, Mr. Scott.
Also, I guess that the amount. Sorry.
Yeah, I'm done with your case. You won. Your objections were granted. And if there is a refund or something, they owe you some money. They said that. And then if there is something wrong with the accounting, you can always file a motion regarding the accounting when you receive it.
I appreciate it.
I'm pretty good at a few things, but I don't know if I can go beyond that.
No, I do. I paid attention to the other cases, so I know what's in the realm of this. And you explained that I can, if the accounting isn't right, I can definitely file another motion. So I appreciate that.
Right. Good day to you, ma'am. All right, Mr. Kite, on the Mallory matter, that's case number 24140622. That is Modern Financial Services Corporation versus Nia Mallory, it appears. The matter is before the court on the filing of objections to a writ of garnishment that is regarding the Michigan Department of Treasury. There's also objection to a writ of garnishment regarding Butterfly Brunch. And then there is an application for installment payments. Those three items have been filed before this court. Your appearance, counsel.
Matthew Kuiper is on behalf of the plaintiff, Your Honor.
All right, thank you. I'm looking for Ms. Mallory now. Say something if you hear Ms. Mallory.
Yes, I'm here.
All right, thank you, and good morning to you. I do see where you filed the objections to the writs of garnishment, and you really didn't provide any objection as such to those items. And then I saw that you filed something regarding making installment payments. What objection, if any, do you have at this time? What are you raising then?
I'm just objecting for them garnishing my estate, and I would like to set up a payment plan so I don't have to keep getting my check garnished.
Yeah, and so first of all, as it relates to the state income tax return, because there is a judgment against you, the plaintiff does have the right to file and to receive a a return as it relates to that item because you have a judgment that's outstanding. Looks like that judgment is in the amount of $11,267 that was entered in 2024. I don't see a valid objection to that. Also, as it relates to your income, they have the right to garnish your income, and I don't see a valid objection there, but I do see where you're asking that they not be able to garnish your wages, that you have a right to make installment payments. That's what you're asking me to do in that regard, correct, ma'am?
Yes. I also wanted to state that I don't understand how the judgment is still 11,000 when they sold the vehicle, and they're I feel like the judgment should be less than what it is.
Okay, the only way that the judgment could be less than what it is if you pay something on it since it was entered. If you're objecting to the amount of the judgment when it was entered by default. You didn't respond to the complaint. So you'd have to go back to try to get that judgment set aside some kind of way. So we start with the judgment that was entered on the 31st of July, 2024 for $11,267.06. So I can't go back into the underlying case. You'd have to try to get that set aside. You didn't respond to the complaint. That's how that judgment got entered. All right, counsel, let me hear from you, and then I'm coming back to Ms. Mallory, please.
Your Honor, I believe the court's already ruled there's no valid objections to garnishment. As for the payment plan, I don't have a copy of the motion for one, and two, I don't have any authority to agree to a payment plan. The current outstanding balance is $11,992. Looks like it's been going up due to some interest, and currently we've received one garnishment payment. So I'd ask that the garnishment stand, Your Honor.
All right, so she's petitioned the court for a $300 per month payment. Ma'am, what do you, that one garnishment payment that you received, how much was that?
Looks like it's $209.98.
All right, so ma'am, do you get paid every week?
The paper I have received, they received $373 of garnishment twice. And they're now, this week will be the third payment of their garnishment.
Did you hear my question?
No, I'm sorry, Your Honor.
All right, so do you get paid every week, ma'am?
I would get paid bi-weekly.
Okay, got it. All right, so I heard the other information that you submitted to me. So what happens oftentimes is that money is being taken out of your pay faster than it's getting to the other side. So they've received one payment. That doesn't mean that those other two payments have not been taken out and that those payments will be applied. All right, so basically, the reason I was asking that question is to see how much you were being garnished a month. So it looks like the garnishment would hit you for about $600 a month. Is that about right?
7, because the paper says they garnish $373 bi-weekly.
Okay, got it. So yeah, a little over. Yeah, so like maybe 700 or so.
Yeah.
So the $300 payment is not an unreasonable amount. The bigger issue here is, of course, the size of the judgment because of the amount of judgment. Those are the kind of things that will take into consideration. So I will allow, on your petition, I will allow the installment order, and I will suspend the garnishment in light of the installment order. I ordered the payments of $300 per month. I'll allow that payment to commence in the month of April for your first payment. So April has 4 Fridays, the 4th, 11th, 18th, and 25th. When do you want to make the first $300 payment?
Sorry, 1 second, Your Honor. I'm just looking at my calendar.
Move quick for me, please, okay?
Yes, I can make the first payment by April 4th, Your Honor.
All right, so I'll set it at 4/4, and that's on or about when your payment would be due each month, okay? And
yes.
I'm signing an order that's going to stop or that's going to suspend the garnishment that was issued. And the funds that have been withheld, those funds will be released to the plaintiff, but this order will stop further withholdings. All right,
Yes.
that is a determination in this matter, and the parties will receive a copy of 3 orders from this court. 1 dealing with the Treasury Department, the other dealing with the employment and then the final one dealing with the installment order. All right, I wish you well. Good day to each side.
Thank you.
Thank you, Judge.
All right, this is case number 23156946. This is LBNB Funding LLC versus Mary H. James. The matter is before the court on the following objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 8th of November 2023 for $16,171.92. Your appearance for LBNB Funding, please.
Judge, may I please court, I'm attorney Richard Roos, and I'm the respondent to defendant's objection, and I'm also the attorney of record.
All right, thank you, counsel. And I'm looking for Mary James. If you're on this Zoom, say something at this time.
Yes, sir.
All right, good morning to you, Ms. James. I received your objections to the writ of garnishment. You said it was not properly issued or is invalid. Tell me what you're talking about there, ma'am. Go ahead.
I don't even understand what it's about because I don't deal with banks. I don't have a bank account. I never had a bank account. I don't even deal with credit cards. And my name is Mary Helen, not Mary James. My name is Mary Helen. Me and my mother both share the same name, but I use Mary Helen on everything.
All right. So I see that the lawsuit was filed in Mary H. James. This appears. So just for a moment, let me find out from the other side what, because you got the judgment already was entered in this a long time, well, a couple of years for counsel. Mr. Rosen, on this matter, in response, are you there?
I have no idea what Chen's talking about, Judge. Like you, I'm looking at the register of actions, personal asserts of the summons complaint back in 2023, judgment entered by default November 8th, 2023. Again, let's see. Let me see the address of the objection. One moment, please.
That's on Collingwood. I see the service was on Bernard Street.
Right. So I have no idea, but I know one thing. Objections to garnishment are not the proper statutory vehicle to challenge an underlying judgment. On that, I rest.
Yeah. So, ma'am, what you're saying is there are court rules that govern the things that can be addressed at different stages of the proceeding. There is when there is a judgment involved, there is things that can be done pre-judgment and things that can be done post-judgment. So this is a post-judgment hearing, meaning that the judgment is already in place. This hearing only addresses the garnishment itself. And the objections to garnishments are things like my income is exempt because of Social Security, or I have an installment payment, or I filed bankruptcy. Those are the kind of things that can be used as a basis to challenge the garnishment. The issues that you're raising are pre-judgment issues. You're saying that the judgment should not have been entered. You're saying that this is not you. You would have to file a petition to try and get that judgment set aside. That's the way that you would go about at least trying to get that addressed, is to try to file a motion to demonstrate why you believe that that judgment should not be entered or should not be entered against you. But without a determination on that issue, what I have in front of me is a judgment that was entered, a notice of lien that was filed after the judgment was entered, et cetera. So that's what's going on here, man. I don't see a valid objection to the writ of garnishment. So let me ask you a little bit about the garnishment, because I see that you put LVNB funding as the, is that where you work?
No, I work at Detroit Institute of Arts.
All right, is that where you're being garnished?
Yes, but I don't even know who those people are. I don't even know what this is about.
I think you told me that already, didn't you? You told me that, right?
Yes.
And I heard you the first time, okay? Did you hear what I told you? Did you hear what I told you? That's gonna govern what you want to do next, because I mean, maybe there's something that you can raise, and when you file your motion, the other side will have a chance to respond to that. What this case is based upon, everything starts out with a complaint being filed. There's a proof of service that says that a complaint was filed back in 2023. And once that complaint was filed, then someone served it at Brainerd Street, apartment 204 in the city of Detroit. They said that they served a Black female in the 40s, approximately 5'3", 165 pounds, braids, etc. They have the time that they did the service, and then there was no response. I want you to hear it. You can tell me that you can tell me that's not you and all that. That's what the file shows, okay? All right, and it shows that that was done on 9/14/23. When there was no response after 28 days, no written response to the complaint, then a default was entered. Then a copy of the default was mailed to Brainerd Street. And then after the default was in place for a while, then an application for default judgment was submitted to the court, and that's when the judgment was entered. And like I said, that judgment was entered back in 2023. I gave you the date previously, November 8th of 2023. And that's, everything else is post-judgment, because that judgment is in place. If you believe that there is something that is wrong about that judgment being in place, you need to file a motion to try and address that and try to get that judgment set aside. That's the step you have to take. I can't take that into consideration on the objection to the garnishment because there is a judgment, right?
Understood.
So I don't find a valid objection at this time. So any funds withheld will be released to the plaintiff regarding this matter. So ma'am, what is being taken by way of the garnishment? I know it's 25%. How much does that amount to per week or bi-weekly?
I get paid bi-weekly.
And how much do they take, or have they taken anything yet?
No, it says on the 17th, that's when it will start.
Okay. And so how much do you usually bring home? So we can see what 25% of that would be.
Roughly now, since we've been slow, maybe 8.
Maybe 8. Okay. So your garnishment would hit you for 200 each pay period, so $400 a month.
Every 2 weeks, 200.
Okay. So you can file a petition for installment payments to try to lower the amount if you want to do that while you're trying to get the judgment set aside. That's one of the avenues that you can take. You can also speak with Mr. Rosen to try and set a payment, and that doesn't stop you from being able to go forward and try and get the judgment set aside. But right now, of course, it's a situation where the money is being automatically taken. All right, so that's my order. I hope that the information provided will help to guide you as you move forward to try and address that underlying issue. Right? I wish you well. Thank you, Council.
Thank you, sir.
Thank you, Judge.
All right, this is a recall. That's right. Not a call. This one.
That's not called.
Okay. Call.
Oh, they do. Oh, okay.
Sad.
I
All right, this is case number 23-165-235. This is LBME Funding versus Cheryl Johnson. I called that earlier. I did not get a response from either side regarding this matter. It is before the court on the filing, set for a hearing on the filing of a motion for summary disposition. It looks like the notice went out on January 14th. I don't know what happened.
Yeah, they didn't say anything, it just showed that they filed it, I set it up. It was rescheduled from last time,
It was rescheduled?
from 10/10, and then 10/10, they were in court. That was the last time they were here.
That was last time that.
Yeah, they were here 10/10, and now the set it for, they had filed some disposition. And she wanted me to set a new date on it.
That's a one more day. Say on.
Okay.
Okay.
All right.
All right, this is case number 24-24-1402. This is Sherry Sabatini versus Adan Medic. The matter is before the court on the filing of a claim of appeal. The matter was heard before magistrate and then appeal to this court. And it makes this a de novo hearing for this court. All right, do I have Carrie Sabatini on this Zoom?
Yes, Your Honor, I'm here.
All right, thank you, and good morning to you, ma'am. I noticed, of course, that the judgment that was entered was as to plaintiffs Ken Sabatini and Carrie Sabatini and Stephen Sabatini. Do I have Mr. Sabatini here as well?
Unmute.
Yes, Your Honor.
All right, now is it Stephen, Stephen, or how is it pronounced, sir?
Steve is fine.
No, I have to have the actual name for it. What is his name?
Stephen is fine, sir.
Thank you, Mr. 17. All right, then do I have Mr. Adan Medic?
Yes, I'm present, Judge.
And I think I said that wrong. It should be Adnan Medic, correct?
Correct, Judge.
All right, got it. All right, the parties in this matter, raise your right hand and be sworn at this time. All parties, thank you. You do solemnly swear affirm that the testimony you're about to give regarding the matter before this court is the truth and nothing but the truth, so help you God.
I do.
All right, very well. Thank you, thank you. All right, so the trial, of course, proceeds with the plaintiff going first because the plaintiff has the burden of proof. After the plaintiff or plaintiffs get finished presenting their side of the case, the defendant will have an opportunity to ask questions of them if he wishes to do so. And after any questions, the defendant will have opportunity to present his side of the case. The court will evaluate both sides and make a decision as to the outcome. Whatever decision I make is final. There is no appeal from this court's determination. Having said that, only one person can go forward talking at a time. So I see that there are two plaintiffs. Who gets to go first? Mr. Sabatini or Miss Sabatini? I'm going to take a wild guess. Say the missus.
Actually, we're gonna have the Mr. go first, Judge.
So I was not incorrect by knowing that it would be the missus that would determine. I'm just kidding. I've been married too long. That's a problem. All right. So Mr. Sabatini, tell me about this matter. I did look at the complaint in this matter, and I looked at some other documents that were sent to me in the complaint. Has to do with the purchase of a watercraft and subsequently damage that was identified to that watercraft, and that you're seeking to recover the amount to repair the watercraft. Is that correct, sir?
That is correct, Your Honor.
All right, so tell me about that. When did this occur? When was this purchase made? Give me some information regarding circumstances.
Judge, we purchased a 1971 Chris Craft Commander boat from Mr. Medic in October of 23. Not our first boat, but it is our first old boat. We did a lot of research on this boat and learned about quirks on the 350Q engines. We entered into a purchase agreement with Mr. Medic for the full price of the boat, with two addendums. The first and most important was that Mr. Medic agreed to properly winterize and store the boat. And that was worded clearly in the purchase agreement. We had an inspection on the boat. We know the boat was running before the boat was winterized, and we received it. Upon taking delivery of the boat in May of 24, we were able to start it. It was able to move from the marina to about 100 yards to our slip. Once it was there, we had pulled the dipsticks and found out there was water leaking in from what turned out to be the two cracked manifolds in the boat. This is a known issue with these boats that we had stated previously to Mr. Medic, and we have a documentation of that on October 12th of 23. And we believe the damage was caused by improper winterization. We asked for proper winterization and full documentation. To my knowledge, documentation was not provided. We were informed that the seller decided to winterize himself, so it was not done by a professional. And then once we determined the damages on the engines, we contacted the defendant, made a request for compensation, and we ended up here.
All right, and you went to someone or under some circumstances to determine what the repair cost would be. Is that correct, sir?
Yes, sir.
All right, and tell me about that, please.
We went to a professional mechanic who we had do the work on the motors. So we've documented the cost on it that we paid for the professional to have the repair made. We believe that this is very, very reasonable, and had the work been done in Mr. Medic's neighborhood, it would have been double.
Let me stop you for a moment from talking on and on and on. I asked you a question, all right? My question gets to do, because we have a record here, my question addresses the cost of getting it repaired. Talk to me.
Yes, I believe we fully documented the cost of repair, Judge.
Maybe you did. Can you tell me what the cost of repairs are for this record, please?
It is $4,000.
Yeah, I have something here, but I can't testify for you. You know, this is like a new case, okay? So tell me what
I'm going through the process, sir. I apologize.
I can go to the
Judge.
17th. Oh, no, not
Judge,
yet, ma'am. No.
Sorry.
I can go to the 17th. If you don't know for sure, then we're gonna go to her and then she'll tell me, okay?
Please do, sir. I don't have that number directly in front of me.
All right, in just a moment then. Let me ask you something else, sir. You, have the repairs been done or you simply have an estimate?
The repairs have been completed.
All right. Anything else you want to tell me about this situation, sir?
I believe that is it, Your Honor.
All right. All right. Thank you, Mr. Sabatini. Before I go to Miss Sabatini, Mr. Medic, any questions that you want to ask of Mr. Sabatini at this time? Any questions? You don't get to testify yet, but if you have a question you want to ask or questions, go ahead and ask him questions.
Yeah, they claimed they had the professional mechanic diagnose this. Does this professional mechanic have any credentials? Where is his business and what's the business name of the mechanic that did the proper diagnosis to determine that improper winterization was the cause of the cracks?
All right, let me stop. All right, you understand the question, Mr. Sabatini?
I do understand the question.
All right, and who did you get, or do you have any information about who actually repaired this and who did the diagnostic on as to what the problem was?
I do, Your Honor. It was part of the submission.
Let me ask you, is Ms. Sabatini in a better position to respond to that question?
I believe she is, Your Honor.
Thank you. Mr. Medic, any other question you want to ask of Mr. Sabatini? I will give Ms. Sabatini the opportunity to answer the question that you posed. Any further questions you want to ask?
Not at the moment, Judge.
All right, thank you very much. I'm coming to you now, Ms. Sabatini. You've been sworn, and of course, you are under oath. Two things before I allow you to tell me what you wish to tell me. The first thing I want you to tell me is what are the damages here? How much money was spent to get the repair done, please?
Yes, $4,019.92.
And who did the repair and the questions that Mr. Medic asked, who did the repair and the diagnostic or the diagnostic and repair?
Yes, thank you. Yes, we found a mechanic by the name of Jerry Scott. He works our boat is in the Upper Peninsula of the UP. So he works for a company called Tassier Boat Works. Prior to that, he worked at Murtaugh Marine, which happens to be the oldest Chris Craft dealer in the United States. So he had nearly 15 years of working at the oldest Chris Craft dealer in the US and very qualified to address this commonly known issue with these 350Q motors.
Let me get two things. One, you said his name is Jerry. Did you say Scott?
Yes, Scott, Your Honor.
Okay. What was the first company that you named that he worked for?
Tassier, Tassier, Tassier Boat Works in the Upper Peninsula.
And then you said there was a company that he worked for before that, correct?
Correct. Murtaugh, M-U-R-T-A-U-G-H, Murtaugh Marine is the oldest known Chris Craft dealer in the U.S.
Right. All right. Now you may tell me, ma'am, what you wish to tell me at this time.
I would just repeat what my husband said. We approached this boat purchase with what could go wrong mentality, knowing the intricacies of these 350Q motors. For that reason, we wrote these clauses into the purchase agreement to prevent exactly this problem from happening, given that we couldn't take delivery of the boat ourselves and bring it up to Traverse City for winterization and storage. We thought we were protecting our interest in this boat by writing this clause into the purchase agreement because of our research. And our worst fear came true when we took delivery. And now we ended up here.
So let me ask you, and then this gentleman may have questions for you. When you took delivery of the boat, this was your first time as owners of the boat, trying to test the seaworthiness of the boat?
Correct, but prior to that, we had had a sea trial and an inspection done before signing the purchase agreement with Mr. Medic. So we had a qualified Chris Craft expert come down and do a sea trial and an inspection. And at that time, everything was working perfectly. The boat was running, and then we entered into the purchase agreement where we added this winterization and storage clause.
So again, my question, and thank you for that information, it's very important. My question is, so this was your first time as owners of the boat to test the seaworthiness of the boat?
When we took delivery, correct. Correct.
You did some stuff pre-purchase, but then the boat was delivered after having been winterized, and this was your first time putting it out, correct?
Correct, correct. It was the initial launch onto the water.
What year is this boat, or some information if you
1971 Chris Craft Commander, Your Honor.
All right, anything further you wish to tell me at this time, Ms. Sabatini?
No, thank you.
All right, Mr. Maddock, any questions that you have on Ms. Sabatini at this time, knowing that you'll get a chance to testify? Any questions that you may have at this time?
Not at the moment, Judge.
All right, thank you very much, Mr. Maddock. Mr. Maddock, you're under oath, of course, and this is your opportunity to tell me what you wish to tell me regarding this matter. Of course, I know that there is a purchase agreement. It seems that the parties entered into the same. I know that the product, the boat was delivered, and I know the parties have a dispute regarding the nature of the damage and or repairs. Talk to me about what you want to tell me about this search.
Right, so the boat is 1971. It is 54 years old. I did sell the boat to Sabatini's back in September of 2023. They did not down for a water test. They did send somebody else. How qualified he was, I'm not sure, but I did take him for a water test. Boat functioned just flawlessly. Had no issues with the boat. They agreed to purchase the boat. They've asked me to winterize the boat. I've owned boats all my life. Proper winterization was taken. I also went further than that. I covered a boat and even provided them with service to transport the boat to their yard up in the Upper Peninsula. And once the boat was even delivered up there, both engines started and the boat was able to move on its own to their slip. What happened after that, I am not sure. The letter that I got from them is dated August 13th. So mind you, Judge, this is about a year after I've sold the boat, and I did not sell the boat with any warranty. The boat was sold as is, and the boat functioned as is, and proper precautions were taken to winterize the boat. Now, the Sabatinis claim that a qualified mechanic was conducting, basically in diagnosing this, but this mechanic, none of the receipts that they provided has any, like even one, he doesn't even have his name or any name or phone number. So there is no business on those receipts that claim that this mechanic works for a reputable business, accredited business. This mechanic is not accredited, does not hold any Michigan marine accreditations to determine that this is the cause. Well, a cause of such causes, I mean, a simple Google search will tell you that an excessive heat from the engine is the most common reason for manifold cracks. So basically, they could have ran the boat hot. Did they turn the water on? Did the boat overheat? Like, this could have cracked. This could have happened. This is basically just a guess, in my opinion, for them to determine and that improper winterization was the cause, while it's basically unknown. And especially from unqualified mechanic to determine this.
All right. All right, anything further you wish to tell me?
That is it, Judge.
All right, so you agreed as a part of the purchase agreement in an addendum that you would in fact take care of the winterizing of the vehicle, is that correct?
Correct. That was all done, Judge.
So you agree and concede that at the time that someone was sent down to inspect the vehicle, that the vehicle used for the watercraft, that it was functioning properly before the winter came, before you winterized it. In other words, before everything was working fine, correct?
Yes, the boat functioned before it was winterized. It also functioned when it was delivered to the Sabatinis. Both engines were able to turn on, and both engines were able to move on its own power to their slip, basically to their water slip.
All right, thank you, sir. All right, any questions that you have of Mr. Medic? One person at a time. If you have a question that you'd like to ask this gentleman, go right ahead, please. Mr. Sabatini, any questions you want to ask him?
I have no questions, Your Honor. I would just like to
I'll come
state
back
that.
to you in just a moment, then. Any questions on Ms. Sabatini?
No, Your Honor.
All right, anything by way of rebuttal at this time? Either Ms. Sabatini or Mr. Sabatini, go ahead if you will.
Yes, Your Honor. While Mr. Medic has questioned the competence of our mechanic, we asked for proper winterization. He decided to winterize himself. So we asked for documentation of said winterization. To my knowledge, there's no documentation provided. As far as I know or have been informed, he chose to take this matter on himself. While he's questioning our expert's opinion, Mr. Medic is himself in no position. He's not certified to judge as a mechanic himself. So we feel we're absolutely right in this matter. We've been very reasonable.
All right, thank you. Anything by way of this rebuttal, Ms. Sabatini?
One last comment, Your Honor, in that what Mr. Medic stated was correct in that the engines did run enough to get the boat moved about 100 meters from the marina to the slip. However, the engines can run while the manifolds are still cracked. So while Mr. Medic, says he's qualified, he's owned several boats before, but I believe this is his first power boat. So I believe he was out of his element. His improper winterization got us here, and we would just like to resolve the matter. So thank you for your time, Your Honor.
All right, now you're not an expert in terms of being able to know whether or not the engine was started with cracked whether the crack was started with cracked. Correct. You're not an expert on that. True. Correct, ma'am?
Correct. That is not me, but from the research we did, that's what we were told with all the research we did subsequent. Thank you.
And that's why I stopped you from doing all that talking, because all of that becomes hearsay. That's what you're telling me. Hearsay. Also, you said something about this gentleman. He doesn't know about whether he sold more boats and all that. You don't know. You don't have any answers on that for sure. Correct, ma'am? Correct.
Yes, Your Honor.
All right. Anything else you wanted to say, Mr. Medic, at this time?
No, Judge, I have nothing else to say. I pretty much say what I had to say on this matter.
Got it. All right. So at this stage, what happens is that the parties get to, that was still taking testimony. Now you get to argue, if you wish to, regarding what you are asking the court to do and what you believe the evidence has shown. The plaintiff gets to go forward first, and only one plaintiff can talk for closing argument. And then the plaintiff gets a rebuttal or final word. And in the middle, Mr. Medic gets to summarize if he wishes to do so. I have to give you that opportunity. If you don't want to say anything, then that's okay, but you do have the right to give a closing statement at this time. And the plaintiff goes first. It has to be an election between Either Mr. Sabatini or Ms. Sabatini, if you wish to close, you may proceed at this time.
Thank you, Your Honor. I would just summarize by saying I, would respect that you honor the initial decision made by the magistrate. We feel like we provided.
Let me stop you there for a moment. Now, I don't care what a magistrate did, and I don't mean that to be any kind of rude kind of way. I don't care what a magistrate does, and whether I rule the way that they rule or not, it has nothing to do with respect. If I see it differently, I see it differently. It's not respect. It's about judgment in this matter. So I had to stop you there, ma'am. I understand what you're saying, but I think that what you're trying to tell me is that you believe the evidence supports the outcome that you're asking for. I think that's what you're trying to tell me, right? Go ahead.
Yes, you put it very well, Your Honor. Thank you.
Thank you very much, ma'am. Sir, anything, Mr. Medic, you want to say by way of summary?
I did, during the initial court hearing, I did provide a video that's to Judge Joseph Boyer that showed that the both engines were winterized, and it showed both engines running. And I showed the judge also the video, and I did show him also a bunch of evidence from my side, Your Honor.
Thank you very much, sir. All right. The plaintiff always gets the last word. So you get the last word, Mr. and Mrs. Sabatini. Before I make any determination, you get the last word because you haven't heard anything.
I don't think we have anything else to say, but thank you.
All right, thank you very much. And thank you to both sides regarding this matter for presenting the information that you presented to the court. The case, while having some complexities without the court sending out an expert to try to determine what was, what became, and what is, the court has to make a decision based upon what seems to be a look at what is reasonable and common sense. Here, the parties are in total agreement with respect to the purchase of a watercraft in 2023. And the other thing that they're in agreement with is that the watercraft was operational, that it met the requirements of the Sabatinis, it met the requirements of Mr. Medic. It was purchased as a boat that was to be seaworthy. The Sabatinis had someone to inspect it for that purpose, and Mr. Medic confirms that it was inspected, that it was in fact operational for the intended purchase that was made by the Sabatinis. Moreover, the parties agreed that the addendum that was reached as a part of the purchase agreement placed the onus and the responsibility on Mr. Medic to winterize the watercraft. That the watercraft remained in his possession and his control, and was winterized by him, and then ultimately was sent to the Sabatinis, and that's where everything breaks down. Is that it arrives at the Sabatinis, and then certain things occur therein. If this was simply a purchase agreement where the parties say, "Hey, you buy this as is, you take it. That's the end of it. Whatever you get is whatever you get." That's the end of the agreement. But you have an intervening event here. The intervening event is the addendum that allows Mr. Medic to take action regarding the watercraft after the purchase of the vehicle. He takes responsibility for winterizing, and as he's mentioned here, other things that he did, shipping and covering the item, but specifically he took responsibility for the winterization of the watercraft, with the understanding that winterization is about preventing the vehicle from experiencing cracks, from experiencing engine-related problems. I mean, I'm unfortunately living here around the Great Lakes and with all this beautiful water around here. I'm not one that has a boat or operates a boat or whatever, but one of my colleagues who was going on now was an avid boater, and in fact, in the midst of winterizing his boat, he passed away. So that causes me at least through relationship, to know that the whole purpose of this is to keep things from cracking, keep things from breaking, to make sure that you don't have water in engines and what have you freezing up, because, you know, water is a wonderful thing, but in an engine with frigid temperatures, it's not a great thing. So, so it seems that what happens here, the common sense part of this, and looking at it from an evidentiary standpoint, is at the time that the boat is delivered to the Sabatinis, yes, they testified that the engines started up. They testified that the boat went out about 100 meters, but that was the end of it. If there was simply a kind of situation where you're kind of just making something up here, then you say that it never started up. You say that it never, the engines never turned on or anything. The engines turning on is almost like a red herring, that if they're busted, then maybe they don't come on. But the fact of the matter is that that testimony rings a great deal of truth and veracity. It causes the testimony to seem to be honest and honorable testimony that, hey, yeah, we got it. We put it out to the water to begin to operate it. By golly, it started up. We get about 100 meters out, and boom, that's it. We get it inspected, and on inspection, the engines are cracked, and that has to be repaired. Obviously, these hearings are not hearings where the court can determine things or should determine things beyond a reasonable doubt. That's a criminal case. In a civil case, the court has to determine things based upon a preponderance of the evidence. If the evidence is even, then it's symbolic to or similar to my hands being evenly in front of me. If the evidence is even, that means that nobody preponderates because the evidence is even. The plaintiff has the burden of tilting the scale, And what can tilt the scale is things that make sense, things that are evidentiary in nature, things that seem to flow from the normal occurrences of events. These parties had a perfectly great relationship until the watercraft was shifted and turned on and put out to sea. It did not do what it did when the expert came to Mr. Medic's place to test the seaworthiness of it before the purchase was completed by the Sabatinis. It did not function in that way. What was the intervening event? The intervening event was that Mr. Medic took on the responsibility of winterizing the vehicles, winterizing the watercraft. He winterized it, he shipped it. Parties, the Sabatinis, they get the boat, they put it out to water. It doesn't function like it did when the expert came by. Something in the intervening part went wrong, obviously. If the Sabatinis' testimony is that they operated the boat for 90 days and then they discovered that something was wrong, that's their problem. There's significant intervening events that could occur within those 90 days. But when they first put the boat out there, it starts up, it moves out 100 yards or so, 100 meters, and boom, that's the end of it. My finding is for the plaintiff in this matter, because they preponderated, they've established sufficient evidence to tilt the scale that the vote that they received was inconsistent with the vote that they agreed upon. And the reason that it was inconsistent was because of the fact that Mr. Medic took on the responsibility of winterizing the boat, and upon doing so and submitting the vote to the Sabatinis, it simply did not function the way that it functioned at the time of the purchase. For that reason, judgment will be for the plaintiffs in this matter for the amount of the claim, which is $4,019.92, together with court costs in this matter. And I'll look now to see what the magistrate did. Well, it looks like the magistrate got it right. I've only been doing this. I don't claim to get it right all the time, but I try my best. I try to be fair to people and all of that. But I've only been doing this for 32 years. So both sides presented their case pretty well here. The evidence is just what the evidence is. It is what it is. And I didn't intend to be rude to anybody in this thing. It's just that if you start talking about something that's not relevant or you're assuming things, I have to stop you and tell you that you can't clutter up the record with stuff that just doesn't fit in. But the case is pretty obvious. It's pretty obvious that something happened between the purchase and the actual receiving of the watercraft. And the reality of it is that the watercraft was tested before it was purchased. It functioned. All the parties agreed to that. If Mr. Medic had set it up at the time of the sale and it got to the location and something was wrong with it, tough. But if he, in the intervening, he winterizes the boat and then he sends it up, there's an intervening event that has something to do with the outcome of the purchase in this matter. It has to do with the damage that occurred to the vehicle. And that is my finding, that is my determination. Judgment as ordered by the magistrate remains in full force. And I would usually issue a different type of judgment, but it's the same order. Because my finding is the same as the magistrate. That means the magistrate got it right. I wish both sides well. Good day to you.
Thank you, Your Honor. We appreciate your time.
All right, good day. Good day.